So we have seen people who go to police lockup, and the police, while they're there booking them, take money from them, for no reason at all, don't document it, obviously. That's an unreasonable seizure. The police officers did not have the right to seize the person's property. Another example is a person being in police lockup and needing medical attention. So the Fourth Amendment protects a person's rights when they're in police custody. They have a right to medical attention, reasonable medical attention. The case law here recently has moved in favor of arrestees, which I was very happy about, to say that the denial of medical care in a police lockup, for example, is judged by a reasonableness standard, which is very low. And so, for example, if someone needs an inhaler and it's, somebody's even in their belongings, or their mom has it out front, or their girlfriend has it out front, and the police just decide not to give it to them, that's unreasonable. You can sue over that. So moving on from the street, police custody, another, I think, really fun area is Fourth Amendment violations that occur in a person's home. So examples, the police enter the home without a warrant, without consent, and without an emergency. That's very likely going to be an unreasonable search. Also, you can probably sue for unreasonable seizure of the occupants. Usually people are detained for hours at a time during one of these home searches. But the three things to look for in a case like that are, was there a warrant? Often people will call and say, well, the police didn't have a warrant. Well, maybe the police didn't show it to the occupants, but maybe they did have one. And again, you can FOIA that information and get that. The next thing to look at is, was there consent? So, obviously most people don't want the police in their homes. Of course, there's exceptions to that. But some people give consent when they don't really want to give consent. I think most of the time, as long as the person verbally gave consent, courts are going to say you gave consent, the police could come in. And so that can be kind of a ripe area, factually speaking, when you're looking at these cases, is really getting the client to tell you exactly what was said between them and the police before the police came in. Now, of course, often the police conduct these raids in the middle of the night, do not give warning or give 1 second of warning before busting a door down. That can be an unreasonable search if they had no reason to do it that way. And then finally, emergencies. So most people, I think, would agree that there should be an exception for the police in these circumstances. So for example, if a woman calls 911, she and a man are screaming in the background and then she hangs up. Well, most 911 centers are going to send the police to the location if that happens. If the police officers show up at the door and through the door, they can hear the woman screaming or getting beaten or someone getting beaten or something happened, the police have the right to go in. That's going to be considered an emergency situation. We call that exigent circumstances. Under the law, it really just means an emergency. Another one that I think should be pursued more often than it is the nature of the seizure itself in these situations. So you might have seen some of these news stories where the police come in and bust down a family's door and they're pointing guns at children and old people. I know that there have been a few cases of these in the news. This happens all the time. I hear this complaint all the time. And I think those cases should be brought. If the police officers come in and they point guns at children, I would sue over that any day, and I have. I think they can be fun cases to do. Okay, so that wraps up the Fourth Amendment. There's a lot more to the Fourth Amendment in terms of your rights. I've included some of those cases in the materials. The Manuel case that I included is a fairly recent decision that talks about Fourth Amendment rights in terms of a continuing seizure. So a person that's held in pretrial detention. Those can be, those are rich source of claims. They're very complicated, which is why I'm not getting into it today. It could be a whole CLE itself, hours long CLE for that one. But that's a general overview of the Fourth Amendment rights. So now moving on to the Fifth Amendment. What does the Fifth Amendment say? No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service, in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. The Fifth Amendment is actually not such a rich source of 1983 litigation. There's a common misunderstanding that you can sue the police if they don't give you a Miranda warning. That's not correct. So we get those calls very often. Among other things, people report that the officer didn't read me my rights. And people tend to, I think because it's so well known in popular culture, people tend to believe that this is a right that they have. And in terms of the criminal context, which I will not speak to because I'm not a criminal defense attorney, the import is different. So the result, if the police officers don't give Miranda warnings, is different. In the civil context, in a 1983 case, you can't sue for that alone. So you cannot sue because the police officers failed to give you your Miranda warnings. You just can't do that. What you can do, and we're going to get into this in the 14th Amendment, is sue based on what happened after they didn't give the Miranda warnings. Did you give a confession that was coerced? And so this takes us to the 14th Amendment. Under the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, the 14th Amendment overruled Dred v. Scott, one of the most famous Supreme Court decisions of all time, which had been decided just 11 years before, which had held the Constitution of the United States recognizes slaves as property and pledges the federal government to protect it. And Congress cannot exercise any more authority over property of that description than it may constitutionally exercise over property of any other kind. And so we 1983 lawyers are big fans of the 14th Amendment. The 14th Amendment says, right after the first part I just read, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So what does that mean? The 14th Amendment, again, similar to the 4th, is a rich source of 1983 rights. The Due Process Clause of the 14th Amendment forbids the admission of an involuntary confession in evidence in a criminal prosecution. So an example here is the Brendan Dassey case. So I included this in the materials. I think it's interesting. It's also a pretty thorough analysis of what a coerced confession means. Now, Brendan Dassey, I had to look this up. I hadn't looked at it in quite a while. The Supreme Court declined to hear his case. So Brendan Dassey, there's very little left that he can do. He's still in custody. His conviction still stands. If his conviction were overturned, he could try to sue based on the coerced confession. He currently can't sue because of heck, which we'll talk about later. But the question then becomes, if someone confesses to a crime, can you prove that it was involuntary or coerced? And so normally the way this would have to play out is a person is held in custody for a long period of time based on a coerced confession and then finally let go. When that happens, once the charges are thrown out, at that point, you could sue for a coerced confession. Similarly, like someone like Brendan Dassey, if his conviction ever is overturned, he could then try to sue for the police having coerced his confession. And the things that courts look at are, what you might think, physical coercion. The John Burge cases are a rich source of 1983 cases here in Chicago. So that's, physical coercion, actually beating someone into confessing. But there's also mental coercion. So aggressive questioning of a person with a very low IQ, for example, or courts look at the condition of the person being interrogated, their age, their IQ, what could you expect them to withstand? There's a lot of interesting discussion about this in the Brendan Dassey case, so that's why I included it in the materials. The other clause of the 14th Amendment that gets a lot of play in 1983 cases is equal protection. And so, again, equal protection cases under the 14th Amendment could be their own CLE. We don't have too much time to get into it, but a very common example we see is, for example, a Black person walks down the street and shakes a friend's hand. A white teenager does that in a different neighborhood. Who gets arrested? Oh, well, we all know the white teenager doesn't get arrested for that, but I have seen many times the Black teenager does get arrested for that or gets questioned for that. And maybe they get stopped and they get frisked, and maybe they have a small amount of marijuana on them when it happens. That can lead to them being in custody and not for a short period of time. So equal protection cases are, I would say, a very fun one to litigate, very worthy cause. They can be very difficult. I think the courts, especially here in this district, I think it's that they don't want to believe it. And so they've erected some pretty high bars to prove equal protection denial. Okay, so that wraps up my short intro into the various amendments that you can look to for constitutional rights. And so now what I want to talk about are common defenses to anticipate. So, before you file suit, you know who you're representing, who the plaintiff is, who you're suing, and your causes of action. But it's very important to think about what defenses you might face. You don't want to waste your time filing a suit and get your client's hopes up if there's some major roadblock in your way. So the Heck bar is what I referenced earlier. This comes from Heck v. Humphrey. I think I included this in the materials. And basically what it means is that if a 1983 judgment would render a criminal conviction invalid, the claim cannot proceed. So therefore, if you have been convicted of a crime, you cannot sue over the validity of that conviction. You cannot collaterally attack it, is the word that the courts use. So for example, if someone calls you and says, I was arrested, they claimed that I beat the officer up or hit him, but I didn't, but I pled to that. I pled to it because I wanted to get out. Can I sue them for that now? No, probably you cannot. There's a lot of variance here. You have to look at what the person was convicted of exactly, and often people do not know. And so you often need to look at the criminal documents, talk to the criminal attorney. What exactly were they convicted of? If somebody pled to reckless conduct, for example, but they were charged with assault on a police officer, you could still probably sue for malicious prosecution because they did not plead to attacking a police officer. They pled to something different. So you have to look at the specifics of what they were convicted of and then what you want to sue for. Heck does not bar excessive force cases. So if there is an incident that occurs and someone does plead to a crime, you likely cannot sue for false arrest, but you can still sue for excessive force. So that's an important thing to remember. The next most common defense is qualified immunity. So this means that an officer can be liable only if they violate rights that are clearly established in light of existing case law. This is a huge bar to 1983 litigation. And so I was surprised to find, where does